You should see a confirmation shortly.
I see it. Thank you. As soon as the atomic clock strikes 1, I will start the meeting. Oh, it's 1 o'clock. Okay, everybody. It is 1 o'clock on November 10th, 2025. This is a meeting of the Land Use Review Board. I am Janet Hurley, the chair. I will ask board members to introduce themselves as I see them on my screen. Sarah.
Sarah Hack, good afternoon.
Alex.
Alex Weinhagen, hello.
Kirsten.
Kirsten Sultan. Hi.
And Brooke.
Good afternoon, Brooke Dingleby.
Thank you. Do we have agenda updates? I believe we do. Sarah?
Per discussion from last Monday, I'm going to ask for the removal of Tier 1A at this time until we take it up again at the end of November.
Okay. And I believe we also need to add personnel matters to our executive session.
So I'm happy to make a motion to delete Tier 1A and add personnel to the agenda.
Okay, thank you.
I'll second. Oh.
Thank you, Kirsten. Is that what you put your hand up for, Brooke? Okay. Any discussion? All those in favor, please say aye. Aye.
Aye. Aye.
Hi.
Aye.
And that is unanimous. Thomas, any
Hello,
public
everybody.
comments for us?
Not on an item not on the agenda.
Okay, thank you. Operations budget and legislative updates. I think I'm just going to add here that at our last meeting, when we were discussing taking appeals, I think our discussion may have been confusing to those who may listen and were listening, in that we suggested that we would not be taking appeals from Tier 2 and Tier 3 areas, when in fact we could be taking appeals from those areas, because those areas, I think what we meant was we wouldn't be taking municipal appeals. And in fact, we may be taking municipal appeals from those areas in cases where there's an Act 250 appeal and the applicant chooses to consolidate the municipal. So I just wanted to clarify that in this, at the outset of this meeting, because our minutes, although accurate, will likely be unclear in that sense. So do we have any operational or budget updates, Rachel, that you think we should put out there today?
I don't have any updates to share. I'll just note Pete Gill is not here, and I think he's going to try and make it to this meeting. So wondering if you want to check in with him when he does.
Yeah,
He may
I'll
have
do that.
something that he wants to add.
Right. He had a parent teacher. He should be here at some point soon. And Jenny and Rebecca, do you have any legal matters that need updating in the open meeting here?
Nothing in open session,
Okay.
unless Rebecca's got anything.
I do not. Thank you for asking, though.
Thanks.
Alex.
Yeah, question, Janet. Maybe it's more appropriate when Pete is with us, but where are we with our legislative recommendations? And do we want to coordinate with Representative Sibilia on the draft bill that she put together?
So we have provided our list to the committees of jurisdiction, and we have a meeting with them on November 21st to discuss them. And I think insofar as at least one of our lists is very similar to something in Representative Sebelia's bill, we can point that out. What do you mean by coordinate, Alex?
Well, there are elements in the Sebelia bill that I think are problematic, and then there are elements that I think are actually good,
Yeah.
serve our purposes and what we've talked about. And so I was curious whether there was any interest from the board in talking to her to see if
Yeah.
she would be interested in revising the bill at all.
Yeah, that's a good point. Yeah, I still feel like it's best for us to, as much as we can, focus on implementation, right? And insofar as some of what is in that bill is more sort of policy shifts, I kind of don't want to go there. I don't know how others of you feel. Kirsten.
I agree with you, Janet. I kind of don't want to go there unless, the legislature may want us to come and provide information, answer questions. And of course, we will do that if and when that occurs. So, but yeah, I think that if others are bringing forward policy initiatives, that's not really something we should be inserting ourselves in. And I think we should be mainly focused on implementation. So that's, yeah, I will also mention, and Brooke, feel free to jump in here too, but with respect to the implementation of the outcomes of the wood products manufacturing study, and there were some very specific, 10 sort of action items, and there were 3 legislation components. Brooke and I had some productive time with legal, developing some wording. We're giving it one final look over, and then we will be routing that, I think, through Pete. So that's forthcoming, and we'll be coming to the board as well to go over. So that's,
do you think
that's it.
Do you think it may be ready before November 21st, Kirsten? So that we could bring
Yes.
board approved wording to that meeting? Okay,
Yes. Well,
great.
subject to board discussion and review. And
Right.
Yeah.
Board approved.
Yeah.
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 So, Brooke.
Not sure which list it ended up being on, but I do feel about the issue of enforcement for Tier 1A. I do feel like that is an important issue that we need to speak to. I mean, I think it's like, is this what you intended? And we don't necessarily think logistically this works, kind of.
Yeah, and that
position
is
about
on
it?
our list. So
Okay.
our list includes a series of what I would call corrections and fixes. It includes the 3 wood products oriented recommendations, and then that one on Tier 1A enforcement. So that's the list that got transmitted to the committees.
Great. Then I think that's where we should end it. I'm in agreement with you. Just couldn't
Okay.
remember which list we put it
Yeah.
on.
Yeah, and actually, I think of all of those things, I just want to put out there again that I think the most important is making sure that we convert Pete's job to permanent. Because right now DHR is not satisfied that the statute made his position permanent, and he would be we would be hanging him out to dry if we don't make this DHR change. Even though finance and management is happy with the way they interpreted statute, DHR was not. So I think of everything that we're proposing, I think that's the most important one. The other, corrections and fixes, they're not going to stop us from moving forward with implementation. So.
Janet?
Yeah,
Just to put a bow on that question that I raised, I'm fine with, the consensus about not really weighing in heavily or at all on the bill that Representative Sibilia drafted. But I like communicating with people even if we're not taking an official position. And I think it's really would be awkward for us to just ignore it and
Yeah.
not have a conversation with her, even if we're not, taking a position or advocating for changes. So is that something that you feel comfortable doing, just to recognize that, like, yes, we know that this came out of your rural caucus and we
Yeah.
attended your rural caucus meetings and we
Right.
hear what you're saying, but we're not taking a position on these policy changes?
right. And I think some of what is in there came out of our discussions during those two meetings, actually.
Yeah.
Providing some money for notification, et cetera. But yeah, I think you're correct. We should respond and we should engage with her on that bill.
Well, yeah,
But-
I just mean like, sort of a cordial acknowledgement that
Yeah.
that we know the bill was drafted and will likely be introduced. And basically to reiterate what Kirsten said, which is we are prepared and happy to come provide testimony if that bill goes somewhere and the committee wants it.
Yeah, yep. Which committee do you
Yeah,
think it will be?
it should go to, House
House Natural
Environment.
Environment, yeah. Okay,
That should be the committee of jurisdiction, but you never really know until the speaker sends it
Right.
where it's going.
right. Okay. Yes, I
Thank
agree,
you.
Alex. I presume everybody is on board with that. All three nods, yes. Okay. Any further comment on this topic before moving on? Okay. We can circle back if Pete has particular operations or legislative matters when he is able to join us. Okay, Kirsten, do you want to do a quick update on the Northwest Regional Planning Commission pre-application proceedings that we are about to embark on this week?
Sure. So Thursday, coming up fast and furious. You all would have received the notice of the site visit and meeting. And, we're meeting at Chimney Corners at noon. There are a number of staff who've signaled that they will likely be in attendance, I think a total of 5. And so, Brooke and I have reserved some vehicles that we can jump into from that location, but we may want to leave. People may want to leave a vehicle downtown if they don't want to stay for the full duration of the meeting. So I think Brooke had said you'd be available to swing by downtown St. Albans before the meeting too. And I was going to see if anyone wanted to volunteer to help with technology, just because, as Janet knows, she and I will be in Williston from 10 to 11 and won't be able to arrive much before, we wouldn't be able to go to downtown St. Albans City Hall immediately before the noon start of the site visits. So if there's anyone who, P. Gill is not going to be in attendance. If there's someone who wants to help with technology setup, that would be great.
I see Sarah's hand up. Is that,
Great.
is
Hey,
that,
Sarah.
yes, I'll do that. Or is that something else, Sarah?
Excellent.
So that's why don't you and I catch up offline, Kirsten?
Yep.
I don't know what time you have that set up and what technology you want left where, in that sort of like public setting while we're off on a site visit, but I'm happy to help. I just don't,
Thank you so much.
we can coordinate.
Okay, I appreciate that. The other thing I thought maybe noteworthy is Josh Donabedian, who's the D6 and 9 coordinators, most everyone knows, is helping me with a virtual site visit because there are a total of, I think, 17 Tier 1B areas proposed, and it's a pretty large geographic area, so we're not able to, cover the full breadth of the region during the field site visit. So to supplement that, we're also doing a virtual site visit, and Josh has been helping me get that set up. And that will be a somewhat significant portion of the meeting time. We've allocated 45 minutes, and we're using Google Street View to jump into pre-populated points and have a look around. And I'm hoping that that is, helpful to everyone and successful. And we're doing a dry run, and, we'll see how that goes. It may be something that others, that's useful for some of the other regional plan pre-application reviews. So, yeah, I don't really have anything else to add.
Is that Alex's hand or Thomas?
Yep, that's Alex. And so yeah, my question, so I have it in my notes here, even though I know where to find it, Kirsten. Starting at noon, and the location for the site visit again is?
So I'll send you the notice. We're starting at Chimney Corners, and then
In
we head
Milton.
out into South Hero. Yeah,
Actually,
we're
is
meeting
it
at
in
a park and ride.
Colchester? Is that
So,
Colchester or Milton?
I think it's Milton. Oh, Sarah's nodding, Colchester.
Sarah would know
Yeah.
exactly where that
Kirsten-
town line is.
Sorry, Kirsten, I'm not asking you because I don't know where to find the information. You don't need to send me the notice. I know where that is. I just sort of wanted it in my notes and for the record for the meeting that
Oh,
in
okay.
case anybody's watching. So
Okay.
Chimney Corners in Colchester at noon, and then we proceed through the site visits, and then we convene at what time for the actual meeting?
So the actual meeting is at 3:30 at St. Albans City Hall. And our
Okay.
last site visit location will occur around 3:00 at, the front steps of City Hall. That will be our, City of St. Albans site visit stop. It may or may not be right at 3, depending on how the timing goes. But the schedule is site visits from noon to 3, and then the meeting is from 3:30 to 6:30, 6:20. So we have a little bit of a break, a scheduled break between the end of the site visit and the start of the meeting.
Excellent.
And
as
we'll
far
bring
as
snacks.
As far as the technology goes, I'm in Montpelier, obviously. It sounds like you and Sarah are gonna confer since Sarah's local to St. Albans, but do you need me to bring the board kit from Montpelier?
So what I was going to offer is I'm going to be in Essex on Wednesday for meetings. So if somehow what needs to come to St. Albans can magically make it to Essex, I'm happy to pick it up on Wednesday and make sure that it makes the final leg.
Okay.
What do you need, Kirsten, for technology?
I'm confirming the size of the screen in the City Hall meeting room. So I'll let you and Sarah know what to bring, and sort of we'll confirm logistics.
However,
We may or may not need the Kando. So
why not have him bring everything to Essex and I can pick it up just in case.
Yeah, so because it sounds like Alex will need to know this afternoon, Kirsten, because he's leaving Montpelier this afternoon, so.
okay. Yeah, if that doesn't pirate things away where they would be needed in Montpelier, yeah, go ahead and bring the Kando would be great. And I would bring the screen, the portable screen. I believe the two monitors in the meeting room are not particularly large, so I'm just kind of confirming what that setup looks like before we make the decision on the Candow and the screen, but or the projector rather, I'm sorry. Projector screen, we do need the Candow.
Handout, projector, and screen, it sounds like, Alex.
Yep. Can you do all
Is that good?
that?
Maybe
As long as
a-
the screen is available, up where the kit is, I will bring it. I've not looked for the screen in the past, so presumably it's
Okay.
there.
There's one in St. J I can grab. If it's not there, I'm happy to bring.
Okay. And maybe an extension cord and a power strip.
Janet, would then you take everything because we're gonna be in Rutland next Monday?
Oh, maybe.
Okay, just a thought in terms of with the roadshow where the equipment goes next, but we can figure that
Yeah.
out later.
Oh, no, because I don't need it in Rutland. Everything is in the room. We don't need any of that for that room. So the answer is no. Okey doke.
Yeah, and I can get it back. Anything that leaves Montpelier, I can get back to Montpelier at the end of that day. I'll be through Montpelier, so that's not a problem to get it returned there.
Yeah, and actually, we are probably having a board meeting on Friday morning. So that location will be 10 Baldwin. Okay, I think we're done with that update, and we can move on to studies and reports. I think we should jump right into the appeal study report. We have a second draft that Brooke provided at the end of the week last week. And let's see, Brooke, do you want to take questions, or what would be most helpful for you?
Let me just give you a little bit of information to start with. If I can share my screen. Just want to report on what is still being worked on right now. The board capacity and timing, this timeline, Sarah and Kirsten are refining it further. They're trying to look more closely at the tier 1A process and timing to make sure that we have that accurately estimated. Kirsten, you want to jump in on that?
Yeah, and there may be some other activities and items of note to insert in the 2027 portion of this table or late 2026. So this was a draft, and I will confer with Sarah about how this was something I helped Brooke sort of put together, this little schematic. So Sarah and I will confer further about the tier 1A information. And then after that, if, Brooke, if acceptable, I will send you a revised draft that may have some other 2027 content edits.
As Kirsten and Sarah look at this, I have two suggestions. One is I think it needs to be on its own page as a landscape mode page if we're going to use this, just because it's too small otherwise to really be able to read. And secondly, I think the colors are problematic. I don't know that we need colors on those on the non-regional plan tier 1A application stuff, because each of those bars can indicate what it's about. And for the regional plan in Tier 1A, probably we need to use something like a a cross hatching or a polka dot or whatever to indicate differences between those different different aspects of the reviews. I'll also note that the last two regional plan reviews will actually take us a little bit into 2027. The Two Rivers Ottauquechee in particular, I had sort of stuffed them into 2026, but they are pretty insistent that they don't need to get our approval by the 31st. And they are submitting in December in particular, and there's no way that we would get them their response by the end of 2026. So those will extend a little bit further. And as I mentioned to Sarah, we will also be developing a community engagement plan to meet our environmental justice covered agency obligations that will be due in 2027. And that's something that I would think that we would be working on, for the year prior. So from the second half of 2026 through July 1.
Thank you,
Everything
Janet.
I
We'll make
think-
sure that gets on there.
And the other thing I was hoping to add to this section is a narrative. I mean, we sort of introduce it and have the
Mhm.
schematic if we're going to use it, but I think that we need to narrate that section a little bit better to explain the specifics.
Yeah.
The other thing that I
The
changed.
other thing, Brooke,
Yeah.
is if we're going to have a narrative, we could just put the schematic in an appendix.
Mhm.
And that way it might be easier to get it in a landscape mode that, I don't know. It might not be, but
That's an
Um,
Alex P thing. I
it's an
was
Alex
getting
thing,
nervous
yeah.
when you were talking about switching to
Oh,
landscape.
I can
know
get
how
it
to
in a
do it in
landscape.
Word, but it's a section break thing.
Oh,
So,
okay. Gotcha.
but
I can get
Go
it in
ahead.
landscape mode and in black and white as well. After I put the color on it, I was like, oh, that probably should be black and white. So thanks
Yeah.
for mentioning that. I'll make that change.
Go ahead, Brooke.
So the other thing I just wanted to point out was I didn't have time to check with Rachel when I sent out the last draft in terms of our cost estimates, because originally we had, more people involved at the different levels. So what I did when I put draft 2 together, I just eliminated one person. But there was a little bit of incidental cost that also needed to be subtracted by reducing the staff. It's not like an in half kind of situation, but so those administrative costs have been changed a little bit. Not much. It's like 123,050 for the one-time expenses in the scenario 1, and I think we're at 125 before. It's just fine tuning that. I just wanted to
Yeah.
be sure people knew the numbers were different.
Yeah.
The other piece that I corrected, I got an email from Judge Zone, and I changed the wording a little bit. He wanted me to specify that he had submitted the Rule 5 request to the Civil Rules Committee. It was not, I changed the wording to say the judiciary did it, talking generally, but he wanted me to specify it was him, not the judiciary, meaning the Supreme Court. So made that change. I am working through Thomas Weiss's comments. There are some that take some thought. He is such a great reviewer and has a lot of good suggestions, some of which I think it's a little bit beyond our time frame to get too into the minutia about like our schedules. So much is unknown that I think we've done a pretty good effort at quantifying what we can. So I think with a little bit more narrative description about how we're using our resources, like like we were talking about the prior section about our timing and capacity. I think those two sections need a little bit more development in the narrative section that I would like to prepare for final review on Friday. If anyone has any specific wording that they want, please let me know. And then the other thing that I wanted to throw out, and then I'll let you all tear it apart and tell me what to change or correct. But I also wanted to just raise the issue of if anyone would like a minority position about any of the pieces or parts here articulated. It could be, I don't think we should switch from the court, but if we're going to, then this is, I'm in support of this, or I think we should take housing, not the other. I've kind of just inserted some question marks or one other viewpoint that was about taking housing, not the tier zoning matters for thought. I don't feel like personally I've made up my mind 100% on anything, but I wanted to be sure. If anybody wanted articulated in a different way or a minority kind of position, let me know or give me wording or create something to add to the report, please.
So Brooke, I kind of want to dissuade us from going that direction at all. I think we should present this as a consensus recommendation. I feel pretty strongly about that. I'd like to hear from others on that. Sarah?
I agree. I think we're getting there. It's taking a lot more effort on Brooke's part. But I think that it would be very nice if we could just arrive at consensus without the minority reports in it. And I do have a little bit of language, Brooke, that I'll get you on some other sections rather than using this time for that.
Yeah, I also have some language suggestions here and there, Brooke. And maybe I can get you offline sometime this week, maybe tomorrow, and we can just go through them.
Sure.
But
I mean, the other way to do it is like a red line strikeout where we can accept or reject or whatever, but whatever works for each person. Yeah, it's a public document if we're all working on it, so I don't know how that works really.
Yeah. I think you would have better control if you were the one making the changes.
Okay.
And that you can interact with each of us that have suggestions to do the redlining yourself.
Mhm.
At this point, I think it could get a little out of control to have all of us poking around in there all week. Do you know what I mean?
Sure.
So, one thing I wanted to point out is that in a couple of places you suggest that for housing projects in particular, delays are problematic and expensive. And I think that that's true for all development projects, not just. And so I think just a little tweak by saying this efficiency is particularly important in addressing the state's critical housing deficit right now, instead of suggesting that it's a problem for housing and not other development. Does that make sense?
Sure. Yeah, I was trying to. The housing advocates were concerned that we had not spoken enough about the housing, so
Right.
That's where my focus was. But,
right.
yeah,
No,
good point.
I think it's important to have it in there. I think it just needs to be tweaked so that we're not suggesting that this is only a problem for housing. It's a particular problem right now because of our housing crisis, and we need to pay particular attention to it for housing. But it's not a problem only for housing. So I can give you some rewording when we talk offline.
Sure.
Then I want to go back to the disposition table. And it seemed like last week we were talking about providing a range, and the range seems to have disappeared from the table.
Yeah, hold on, let me bring that up.
That's on page 28.
Yeah, I was just trying to get so this was the higher end of the range. I just isolated what we had put in as the one number at the top. Just sort of like for comparison purposes, so we only had one number to kind of look at as we were looking at the two. And we were trying to, I was trying to be realistic about how much time we could really cut it down. I'm not 100% there yet. What I'm still working on is drafting like a pre-trial schedule form that has discovery that has
Yeah,
like the
and-
case events, and then I'm trying to work backwards from that. So I will
Yeah.
have more information on that by tomorrow.
So I would like to have a board discussion today about
Okay.
that, and to sort of get some ideas from each board member about what the structure of an appeal would look like before this board. And, and talk about motion practice, as part of that. So that you can
You want to see
have
the
some,
other? Should we look at the other, what the court does? To give you the,
I mean, I don't know that we need to look at what the court does. I want to hear from each board member about what they would envision an appeal hearing before the board to look like. And my model is a DRB hearing. And it, you don't have to have a lawyer. You don't have to have, you have a hearing and everybody is present at the hearing, and everybody has a chance to present the information that the board needs. And if the board feels that it needs more information, it can continue the hearing. But I don't know that we should be providing opportunities for lawyers to submit motions that we then have to give them 30 days and everybody else 30 days to respond to. I feel like we should be doing this in the context of a warned hearing, and only continuing the hearing if need be. And so I'd like to hear from each of the other board members about how they would envision this happening before this board. I think one of the more important reasons to consider this board hearing appeals is to expedite things. I still believe that it's really important for our program that we hear Act 250 appeals, but the other important consideration here is that we have the potential to expedite the appeals process. We also can provide a much more accessible procedure than the court. Sarah?
I first of all just want to hear Brooke's response to that, because there are some things that I've appreciated as we've gone along, and particularly with de novo, where we're seeking to limit the amount of supplemental information. There are legal limits on what we can and can't do in terms of expediting and limiting motion practice. So I don't know, Brooke, I'd be interested before I chime in, hearing your response to what Janet stated.
yeah, this is a really tough one. And by the way, the other thing I forgot to tell you is I have gotten back to the board rules, and I will have a version to look at and put in as at least a rough draft addendum or appendix. And in doing that process, I mean, I've been litigating for 30 years, but it's like all the possibilities. And the question becomes, what can an administrative process do to stop motion practice, or reduce it or whatever. And that's the piece that I am running up against a blank wall at. It's like the judges talk about, we can give you a hearing 2 weeks after you arrive at our doorstep. The problem is that the parties aren't ready. Their lawyers need to prepare, blah, blah, blah. And that's the thing that I don't know that how much control that we can assert. We still always have this notion of due process. So if somebody files a motion and says this person shouldn't be here, they don't have standing, or they don't really live in the neighborhood, or that kind of thing. There are limitations to what you can do to slow that down, which is why what I've been looking at is let's shrink the time frames. There used to be, like in the e-board rules, there is a summary judgment rule, but it just mimics summary judgment, and we don't think it was used very often for getting rid of cases back then. You saw actually little motion practice because it was like a redo of the district commission, right? It wasn't going and arguing about on the record reviews. So, the on the record is a totally separate, just briefing situation. And that we can control, I think, as long as we can get the records. That was the one problem that they're having in that arena. But when you are talking about adding new evidence to the proceeding, people don't want to be, they call it, trial by like guerrilla warfare kind of thing, people not knowing ahead of time what's going to go on. So what the other thing I'm trying to do is I'm trying to create a pretrial order that says you have to tell us who your experts are, who your witnesses are, send in all of your documents, and then, before the hearing, so everybody has that information, and make expert disclosures to shrink it down and saying, if you want discovery beyond that, you're going to have a really good reason. So that's an area that we can shrink the time frame, because discovery tends to go on, and people want depositions sometimes. And that's what we want to be able to shut down. Motion practice, I am more concerned about, because I don't think that we have the right to say, sorry, there's a constitutional standard here. It's the Fifth Amendment. It's the government can't take your property without due compensation. So if we're impairing property rights, that's where the standing arises, if they could be harmed by the decision of the government.
So, but DRBs do this all the time. It's the same.
Right.
It's a property rights issue, and they're rarely lawyers involved. There isn't motion practice. There's a hearing, and it gets continued if need be. And people are sworn in, and they give testimony during that hearing. I don't know that, if I'm not convinced that it's an absolute requirement to provide due process that way.
So Janet, I think what I'm hearing, I just want to reframe what I heard from Brooke, is legally, we can't stop people from making those motions. However, I think to address what Janet is saying, I think within our rules of procedure and how we choose to sort of frame everything up, we can improve how we respond. And much like that sort of DRB model where we say, sorry, the hearing is now closed. You have up until the close of the hearing to do this. And perhaps within the structure that we create, enabling either the chair or hearing officer, somebody to take those range of motions and deal with them. So we can't stop them from coming in, but the way that we deal with them, I think, is something that we can exert more control over and be a lot more refined, if that makes sense.
Yeah, and the other thing we got to keep in mind, we're the appellate level. We are the, if something goes wrong level below. We're supposed to be able to look at that fresh, or, fix something if it went awry. And that's where you see these motions coming out of. It's the standing, it's the, trying to knock people out of the box. And the other thing that often in practice with motion practice, if you argue about whether or not, how do I say this easily? Sometimes it's easier and faster just to deal with the issue and, resolve the motion instead of arguing about whether or not you get to make it. It's like all of a
Right,
sudden and it
right.
becomes a mushroom cloud, right?
Right.
But I think shutting it down to really tight timeframes, that's what the PUC does. And it is all hands on deck. If you get a motion, you got to turn right around and get a response in immediately. Same with discovery. You have a week usually to answer interrogatories. Now, hopefully we won't be doing that. But if we grant somebody the right to do discovery, we will be able to say, and it's got to be lickety split. You have 2 weeks or something like that. That's how I see us not butting up against due process, but shortening the time.
Alex?
So I agree that I would like to focus on the timelines and then design a process that works within much abbreviated timelines, not the year, not the 9 months that are, that the court model uses today to resolve an appeal of a jurisdictional opinion, for example. I think that we're making recommendations to the legislature. None of this is going to be codified in stone by the legislature, right? This is, if they choose to do this, it's going to come back to us. We're going to have to write rules of procedure to govern it. So I don't think we need to worry too much about getting it perfect right now. But my focus is on the timeline, expediting, as Janet said. And Brooke, you're the expert in this. I'm not. So I'm really interested to hear from you, like you've been talking about, like what are the common types of motion practice, but interrogatories for discovery purposes, I think you're implying that we could limit those. I would like to have them be eliminated. I think that, similar to Janet's suggestion, if we're going to hold a hearing or a trial, whatever you want to call it, we should have dates by which people submit their any additional evidence, and that becomes public record and everybody sees it, and that's the end. There's no like lawyer telling the other side, I need you to produce everything that you're potentially going to mention, and you know what I mean? Like, why do we even need that in the process?
What I'm suggesting is that discovery is not the norm, it's the exception. And if there's a good reason why somebody needs discovery, like I got these expert disclosures and you didn't tell me anything about where the expert is getting his information from, or I want to talk to him because, an expert has an opinion, there are facts upon which they base their opinion, and then there's, information that they have knowledge of or referenced. So somebody might want to talk to them about, the stormwater standards and, whether or not you figured it out right or not, as opposed to, and discovery is designed to educate the parties so that when you get to hearing, you're not doing it and wasting everybody's time, the court's time, the board's time. It's so that you understand what they're going to say. So, but in my, the way that I'm looking at it, we're going to require an expert report. Okay, that's what your expert is going to put into evidence. We're not going to sit around and listen to him or her. We're going to put that in, and it's just the facts, ma'am. And cross-examination can happen on that.
Gotcha.
So
that's helpful. I still feel like, again, we can work out the details later, but I feel like I've seen interrogatory requests be weaponized in the past in environmental court, and I'm not interested in that happening through our process. So I prefer to eliminate discovery entirely and have an expectation of everyone submitting materials with plenty of advance notice so that once you get to the hearing, folks have had a chance to look at them and be prepared with the question if they need it. hold on.
Well,
doorbell.
you know, I mean,
have
one
more
of
to say, but go to someone else.
Yeah, let me just say one more thing. I mean, one of the most basic elements of due process is notice of the information that you're going to be confronted with or that you want to confront. And that's why discovery is there. I don't think you can say you can't have it because we are not doing an on the record review for everything. We are taking a hybrid de novo to some extent approach. And I think that you're going to we don't want to create a system that's going to then be litigated where there's going to be a lot of motion practice saying this isn't fair. So we're trying to find a balance. Okay. I don't think we can just say, no, you can't file motions. I don't think you can say, no, you can't ask for discovery. It should be, and it is right now in the court's discretion, whether you get discovery at the e-court. And, you know, we could say you don't get discovery unless there's a really good reason. And we get to say what it is. You get to ask 10 questions. You know, we could limit the number, something like that. But I am concerned about the blowback if we say, oh, too bad. Because the other thing you have to keep in mind is we don't want to then force things down to happen below, like lawyering up down there. So if you know that you're going to go to a partially de novo hearing, you're going to want to do all your stuff below because you may not get the chance to know what's, you know, to fully feel like you're litigating above at an appellate board. I mean, I have asked all the lawyers, tell me what to do here. Can we limit motion practice? And I have not received anything other than control the time. What
Yeah,
type?
with all due respect to your colleagues, Brooke, I don't want to be beholden to what the attorneys are used to when creating a whole new process that is an administrative review and not a court, not part of the court system. I think ours should be a bit different, not entirely different, but a bit different. And so, but I'm sensitive to what you're saying. And if you think that the best practice is to say, well, everything that you're used to will still be available to you, but we're going to tightly limit it and the time horizons for doing it will be tightly limited, then maybe that's the way to go. I just thought it might be cleaner to be honest about, discovery not happening in this process, and here's why. But if that's not the right way to go, that's okay. I was interested in hearing you talk about like the typical types of motions that are made. And I do feel like your point about making a motion to argue over somebody's interested party status is a pretty common or likely motion that we would need to entertain. So I can see that one staying in the mix for sure, and being having our timeline account for that, but also still be very limited so that it doesn't result in a lot of back and forth. Yeah, I guess I'll just end by saying I'm mostly interested in the timeline. I prefer to see the ranges and or the shorter end of the stick on those numbers that you put up as opposed to the top end.
Yeah, so often you set a schedule in a case, and I'm not talking about environmental court per se, and then what happens is a motion gets filed like a summary judgment and it blows the entire schedule up. You can no longer file the schedule because the other side has 30 days to respond. Then the first side gets another crack at it and a reply. And then you have those 30 to 60 days for the court to make the decision. Sometimes it goes to 90.
That's what I want to fix. That's what I want to do differently in our system. I don't want the ping ponging of motions to delay the eventual hearing or trial. So just one example, I understand exactly what you're talking about. Someone makes a motion for summary judgment, right? Anyone, other interested parties can respond to that. Then there's an opportunity for the party that made the original motion to respond to the responses. That seems preposterous to me. It should be a motion. There should be allowance for responses, and then the adjudicating body should rule on it. And it shouldn't need to go back and forth, an extra time. So yeah, I would love for our process to tighten up the timelines and also tighten up those processes so that it's faster
Well, the E-Board had a summary judgment rule, the exact same timeframes that we have in our civil rules, and nobody ever complained about. I mean, because you have to remember, summary judgment is a dispositive motion. If it gets granted, it means the case is done. Either they get their permit or they don't get their permit. So there's a real useful purpose to it. In fact, one of the things that our general counsel has suggested is, right as she gets cases, is to size them up and see if we can, dispose of them by summary judgment right out of the gate to speed things up. So it is a mechanism, but the problem that we face is sometimes, as you say, it's weaponized.
Well,
So
it shouldn't take that
can we
long in my mind.
reduce
If
our
there's no
decision
dispute in the
time?
facts, that's what a motion for summary judgment is, right? It's a contention that there's no dispute in the facts of the case and that the appellate body can make a judgment right now. So if that in fact is the case, it should be really easy to get a response from other parties and then for us to make that determination quickly. Because if we say, not sure, then the motion's quashed and we move on towards the trial. And that shouldn't be a 90-day process, right? That should be make your motion, get a response, issue a ruling, and onward, in my mind.
Well, but even the process of writing a summary judgment decision is a very lengthy process. It needs to be researched and written, typically by a lawyer. And, okay, if we think we can, get it in half the time, do it in half the time than the court. I mean, the problem is I don't have any basis to make that representation. And honestly, that is the biggest thing I'm worried about this entire appeals report, is that sure, we can say we can do it faster on a piece of paper. Can we make that happen in reality? And I really don't know the answer to that, because so much happens during litigation. The goals that they have, sometimes the case gets blown out of the water or it happens like in a nanosecond. And so the guidelines are how long an average case should take. So what I'm trying to do is take the pieces and parts of the system and say, let's shrink them down. But on a summary judgment motion, I don't see any way to reduce the amount of time to either give people to respond to it. It's dispositive. And, just to say, oh, well, there aren't any facts in dispute. Well, that means which expert do you believe? Is there an actual dispute in expert opinions? That would be a dispute of fact, unless you discarded one of them and didn't think it was credible. So summary judgment sounds very simple, but it is the same process of analyzing through, application of the law to the specific facts of this case and writing the decision. You're still doing the same function. It's just that you're reading it on a piece of paper instead of somebody telling you it verbally at a hearing. That's the only difference.
Yeah, I do think there's a substantive difference between granting a motion for summary judgment where you have to make a decision on those facts and denying the motion for summary judgment where you're simply saying, as an appellate body, there are facts in dispute. We're going to trial. That I think there's two very different time horizons and levels of work involved for those different outcomes. But I guess where I'm going, Brooke, is that I'm happy to have us parrot the court system with tighter timelines the way you're suggesting, if we can get there. But if we can't, then I'm actually more inclined to Janet's suggestion of saying this should be an administrative hearing. There should be no discovery. There should be no motion practice. You will come to the hearing and make your case. And if we need to continue it so that you can, provide additional information or contest someone as a witness, you can do it at the hearing and we'll push you forward. I think I'd prefer to do it your way, because that's what everybody's used to at the court level. But I want to be sure that whatever we're designing is not just our version of the court with the same result, which is very long, very contentious. And, why did we take appeals if we're just doing it the same way?
Well, I'm patterning it after the e-board. The e-board had motion practice and discovery. And nobody had a complaint about the time back then. It was about consolidation. They wanted everything going to one place, as far as I can tell from my research. But I hear you. I understand what you're saying. I don't know that we can accomplish that.
Yeah, I hear you too.
I'm not sure.
Kirsten.
Well, since Janet was interested in kind of all of us discussing this, I'll just jump in to say, yeah, I think ideally you have all the information as just a straight up administrative process, but we all know, there's a certain inevitability that often people want to provide additional information when they get to the appellate level. And so I think retaining, the due process is really important, and we need to tighten up the timelines. I mean, Alex, to your point about the ping pong, I mean, I think that if information is provided and there's an opportunity for a response, you can have that sort of third timeline that's just tight, that provides, a final 7 days for, a further rebuttal. So I think all of this can be spelled out in the rules of procedure, which I think that it would be helpful to people evaluating this recommendation from the board to see as much of that detail as possible, as much that we can nail down as part of this report, I think is helpful to, for everyone to understand exactly how it would operate and what those rules would be. So, limiting discovery to me makes a lot of sense, and just tightening up all the timelines.
Sarah, do you want to weigh in?
I don't know how much further I want to weigh in, other than I understand all of it. And I think what I'm hearing from Brooke is not being sure if we can legally accomplish what we all want to. And I'm wondering, just to throw it out there as a question, how much of this needs to be in the report versus what we tackle in the rules later on?
Yeah.
Well, I think Kirsten's point was that it'd be nice to have the details, as much of them as possible. But Kirsten, while I agree with you, we're 7 days away from publishing a report. And I'm not going to ask Brooke to do magic and try to, gel our 5 different opinions on how to make it work, when it sounds like we have some disagreements about, or at least difference of opinion about, administrative hearings versus, more of a traditional appellate court function. So as much as I would like to see it spelled out, I'm kind of thinking we're not going to be able to spell it out. And best we can do is say, here are some of the ways that we would like to improve the process, and the details will be determined if and when the legislature wants us to move in that direction.
Yeah.
Yeah, we're not going to have every I dotted and every T crossed in the next 7 days, but it's, to the extent we can articulate, some of the main elements, I think that could be helpful.
Let me share my screen for a minute to show you what the rules look like that I'm working on, because they're not far from being a rough draft anyway. Hold on a minute.
Just while you're doing that, Brooke, I just want to say that I feel like the report as you drafted it last week is pretty close to being ready, and with some language tweaks and here and there, and some more information in the appendices. I think it's there. I think, as Alex said, or I can't remember now who, we don't want you to be working miracles over the next 7 days to get a whole bunch more information that isn't already at your fingertips and articulated. We just need to, I think, tweak this to make it very clear what our recommendations are, and that, and as much as we know at this point, to present that. What were you going to show us here? This is one of
Um,
the appendices?
Yeah, this is, I mean, this was the rules that I was working on that would be put back into our procedural rules. They're based on our original e-board rules for appeals. And I've tried to merge the requirements of on the record of appeals from how we're dealing with them at court to try to stay as consistent as possible. So I have all of the mechanics pretty much outlined, how, and it's very, very similar, as I say. And here we have to, put a rule in our thing to be similar to the references that we have here. But these are, these are the mechanics. I've done the hybrid trial and doing a pre-trial order. I mean, do we need to sit around and tear this apart and micromanage all the little, language and everything? No, but I do think it's important to say, okay, well, here is a rough draft. We can create procedural rules if we're going to be the appellate board. And here's how we are articulating at least the first draft of it. Lawyers haven't looked at it, blah, blah, blah. Because I do feel like I put a lot of effort into it, a lot of time. And I feel like I would like to show them, okay, there's a work product here. It's not just in somebody's mind. So I can tighten it up a little bit, fix some of those references, and we can put it in as this could be an example,
Yeah.
of, we
With
never
an
intended to.
example rule watermark.
Yeah, we never
Yeah.
intended to actually create the rules because why would we? We don't have enough time and resources
Right.
and people,
Right.
unless we're really going to do it.
So Brooke,
How-
I think you were planning to get that to us, and then we have a special meeting scheduled for later in the week, so we could talk a little bit more about all of this, whatever's left over. So I'm happy to do that, but at the same time, like, it's time to close this out, I think. And I haven't seen that document that you just showed at all. And I am a nitpicker, so I don't want to go tear it apart, but at the same time, I kind of want to see it before, we decide that it's worth including. So I'm willing to do it later in the week, but I'm also wondering if it makes sense to simply reference the old e-board rules, which is what it looks like you were marking up, and say, this is an example of what we could return to and then adjust for this model without actually doing the adjustments. I don't want to negate the work you've done, though. So if you feel like you've done a lot of work marking up the old e-board rules, let's look at them. You know what I'm saying?
Yeah.
How many pages was that, Brooke? That document?
17.
Yeah. That's a third
It's a
of the
lot.
report.
I mean, I've worked really hard on it for a long time.
Yeah.
Okay. I'll look at it, Brooke. I'll look at it.
let
Just,
me-
we're running out of time, and I got comments that I'd like to get to on what you have supplied us.
Right. Right.
Before we get to 2:30 today.
Yeah, let's move on. I will see I'll look at it and send you guys something that we can
Yeah,
say,
and-
keep it in, throw it out, whatever.
Yeah. I think if we do not include it as an appendix, that there definitely needs to be a paragraph or two added to the report that discusses this. So, if you feel like if we can present it as something that is, a work in progress that is based on the environmental board rules and that, is a model for what we can work on should the legislature decide to send appeals to the board's way. It just needs to be carefully included in that way. Then maybe we don't need to each of us nitpick all 17 pages of it. Do you know what I mean?
I don't know what you guys are going to nitpick, honestly. I mean, it was the e-board rule. It's consistent with the court rule. I mean, I hear what you guys are saying about, we want an administrative process that's very different. That's not what I've developed. I've developed our version of the court system, basically, I guess, which is what is sounding like some of us don't want.
Well, I feel like we only have a week left. And I feel like this conversation we haven't had occasion to have this conversation until today. And I think that's a little bit problematic. So I wonder if we can say in the report that, that the board would need time to look at this further in terms of describing the process by which we would undertake an appeal.
I don't think that these board rules are the issue. I think the issue is I think there's like a fundamental difference right now about what Alex was talking about, an administrative process versus
Yeah.
what I had in
Right.
mind for sure. I don't know about others.
Right. And what I'm saying is we only have a week left, and this is our first occasion to really discuss that. And I'm not sure that we can resolve that question or that discrepancy between the two before we issue this report.
I think that's the whole point of the report, though, is what my concern is. And this doesn't have anything to do with picking apart a rule.
Right. I agree with you, Brooke, but
yeah.
we have not, as a board, had this discussion until now. And so I feel like we need to acknowledge that we need to have more time to have this discussion.
Can we discuss
Well,
the rest of the report before we run out of time today?
Sure. Yeah. We have 20 minutes left on this.
Cool. I've got a bunch of questions / comments that I can run through, but I'm happy to yield the floor to Kirsten or Sarah if they have similar points, because it seems like, Janet, you raised one and I riffed on that, but I don't know that we've heard from Sarah or Kirsten.
Go ahead, Alex.
Okay. So sorry, I just need to bring my document up here with my comments. And I'll try to eliminate as many as possible so we can move through. Okay, so Brooke, I'm on page 6 of the report. And towards the bottom of the page, there's a paragraph that begins building on the findings of the 2023 report. And the last sentence talks about that in place of the Land Use Review Board, in place of the Natural Resources Board to oversee the administration of Act 250, mandating that the new board undertake rulemaking, implement a tiered jurisdiction system, develop new administrative guidance and policy documents. And then here's the part I'm unclear about. Initiate plan review and approval processes. What did you mean by initiate plan review and approval processes?
Like the regional plan and the tier mapping approvals.
Perfect.
Yeah.
Can you just put the word regional in front of plan, and then I think it'll be clear. I just wasn't sure what that meant, so I imagine another reader might be confused as well.
Yeah, got it.
That's an easy one. Let's see, what else do I have here that's of substance? Okay, I'll skip that comment. I guess I want to go to a point that Thomas made, and he's in the room, so he can back me up if he wants to. But in section 9, Roman numeral 9, and that's on page 22. This is the section of the report that's the court versus the board debate. And I still have the same reservation that I had, and I think Thomas had a similar one with the first draft, that it seems to be like making the positive case for both sides of it. And I feel like we're at the point, like, if we're gonna make a recommendation that the board take appeals, we ought to rework this section a little bit to just highlight the positives of doing that. And make a stronger case in this section of the report for what the recommendation is. Now, I don't mean that we need to throw out or like ignore the potential positive sides of the court model that we have today, but I wonder if there's just some way to recouch it or, you know, focus more on the positives of the board model. That was, yeah, that was a substantive comment for this section of the report.
Can I follow up on that? And I feel like that is fairly easy to do here. For instance, in the numbered paragraph, expertise and specialization, the last sentence, if it were just reworded to read the land use review board, or, sorry, the transition to the land use review board could lead to a loss of institutional knowledge and legal expertise. Instead of, it's sort of de-emphasizing the negative, and it's a little bit more just a little bit more direct, I guess, and de-emphasizing the negative for transferring it to the LURB. And then if you were to, and I feel like, for instance, then on the number 6 paragraph, if you were just to eliminate the last phrase of that paragraph, which might be more challenging to achieve with a separate land use review board, just put a period after framework. And then in that conclusion paragraph, take out that last sentence completely. These factors collectively argue against. These are the factors. You don't need to sort of emphasize that they argue against. I mean, these are the arguments for why it's working at the court. But at the other side, we have arguments for why it would work at the board, and you don't need to compare them in every paragraph, if you know what I don't know if I'm being clear, but
Yeah, I do follow you. I tried actually to stay more like, here are the positives and not necessarily compare them, but that I thought there were two that I thought were really important to, because I felt like you didn't understand why it was being said. But I feel really protective of this section because this is about pleading the case of one side and the other side. It should not be manipulated by the way we want to present it, or we don't want the board to sound in a negative way. We need to show both sides equally. And I have tried really hard to not do the negative thing, but I felt like on that one issue, actually, I was using what VNRC, the one about over time the board would, gain expertise. I was taking the VNRC argument to say, there will be development of expertise over time kind of notion that they were sort of arguing back with that. I mean, I'm happy to, strip it and make it more just like the positives and not necessarily to compare them. But that's where I'm coming from on this. I feel like it's really important to be very objective on both sides of the fence.
Right, and I feel like,
and maybe
the
I'm not.
the
now doing
constant
that.
comparison is less objective. If you just present it without the comparison, then the comparison is there because they're side by side in the report. but to include those phrases and is sort of arguing against when I don't think you need to be doing that there. We're presenting the positives of each side by side and letting the reader, see them.
Gotcha. So I got the last sentence in right before the B.
Well, I can,
Yeah, okay,
we can go
over
through
these
this
later.
offline.
Yeah.
So,
Okay.
yeah.
Okay, yeah, so take it however you want it to go forward with it, Brooke. I'm not looking to have you rework the whole section. I just found it awkward because it feels like if I were reading this, I would get to that section and say, I don't see a strong case for doing anything different from what we have today. That's all. So, but there are a few.
That's 'cause there
sections
is a
further
strong
along where they
case,
make the
Alex.
recommendation, so that's okay. So let's see, the other comments I had were, the table of, resources needed in section 12, Roman numeral 12 on page 29. You mentioned earlier that, there's some tweaking was still needed there, I guess. But I'm of the mind that there should be one scenario, not two. And it should be one legal services specialist, not an attorney. And that would serve for everything we aim to do with these recommendations. That's where I was last time we talked about this. I'm happy to be overruled if the rest of the board wants to show a more expensive scenario with another attorney. But I don't think we need another attorney, even in scenario 2. So I'd like to change the cost estimates accordingly.
So how about this as a compromise, Alex, to preface this table with a narrative that explains the unknowns. And under scenario 1, everything proceeds as Alex Weinhagen is envisioning, right? We're not going to need 2 lawyers. Under scenario 2, maybe there's a lot more, there are a lot more appeals than we might anticipate. And if so, this is what it would cost to have us another lawyer added to the team.
Yeah, I appreciate the compromise suggestion. My preference is the same. I'd still prefer to have just one set of cost estimates and to not assume or incline that we would hire another attorney. I think we have enough attorneys, and if we're pushing this out as far as we are, 2028, I think we'll have capacity. But like I said, if the rest of you want to show more detail and more costs with another attorney, then okay.
Can we hear from Sarah and Kirsten on this?
I'll let you talk first, Sarah. That's okay.
Nope, I'm happy to either. I think Alex framed that up of, I don't know, Brooke, do you think we can make it without an additional attorney? If we wait, because I know we were talking about the whole landscape of options. And I think back when we were looking to start sooner, we need another attorney, but if we push later, we don't. Do you think that we can make it without an additional attorney?
No.
Well,
Not
let
if
me
we take on
rephrase that.
zoning. I just don't. I mean, maybe Jenny can jump in. We were talking about 2 attorneys earlier on.
Right, but we're talking like 3 fully staffed, like the board has 3 staff attorneys. Can we make it with the new, without adding 1 beyond the 3?
Yeah, I think, what we're talking about is, we have our Act 181 attorney. So most of that person or a person in that position could then be an appellate attorney. But the other capacity is only losing the not prosecutorial function, but representing the board as a party in the environmental division. We still have all the enforcement stuff. So the only freeing up that we have is that we're not litigating anymore as a party there. So I don't see that as a huge, I mean, it's more work to do, to write the decisions than to be a party in court. So that's why if we're talking about like 1.5 attorneys that we will then have at our disposal for appeals, that just sounds too small a capacity to me, because you're having to firewall attorneys off from helping the below if they're helping a district commission or a coordinator, and they might not be able to sit on that case. I think that we need more. If Jenny has any difference of opinion, speak up.
No,
I would
think
be very
your-
nervous to say we didn't need another attorney if we were
I'd say-
taking zoning.
Brooke's comments reflect the discussion that we had, particularly about the ongoing litigation needs.
Kirsten?
Well, I guess some of this goes back to, Janet, you and Sarah, and I don't know how others feel, but landing on a consensus position with respect to the scope of appeals that the board would recommend that it take. And I'll just be very candid. I mean, I'm just not I'm not in the same place as insofar as thinking that the board should, in addition to Act 250, also assume responsibility for appeals of all types of projects within Tier 1A and all of the housing in Tier 1B. I think the next step beyond Act 250 would be all housing statewide. And I know I've been saying this, and I think it's perfectly fine if there's some, sort of footnoted minority position on a component of this. I mean, wouldn't be surprising. I mean, let's face it, people have been debating this topic for a really long time. And so it's okay, if we're not all completely unanimous on some element of it. So for me, I'm if we're talking about taking all the zoning appeals, sure, of course, we would need more legal capacity. But that's not where I think we should go. So.
Okay, well, that was my question or comment, and it sounds like from what I'm hearing, most folks are happy with the two scenarios, and I don't need to have a minority opinion on this one as far as I'm concerned. So my last question for Brooke is, just gotta find it again here, sorry. On page 35, it's really page 34 and 35, we're talking about recommendation 4, how to prioritize and expedite housing appeals. And this is where we say that we're recommending transferring appeals from Tier 1A areas and housing appeals from Tier 1B areas to the board. So on the top of page 35, letter D, it's 1D, it says centralized governance. I'm not sure if that's the right place to put my comment, but Sarah had made an argument during one of our discussions about this that there's logic to taking just municipal appeals from those areas, because we are reviewing and approving those areas as a board. So we have greater familiarity with those areas as opposed to municipal or housing permits statewide. And B, that the state has prioritized those areas for growth. So it makes sense that if we're looking to expedite housing, that we first focus there, although we might choose, we might recommend more later. And I was just hoping that those 2 points could be added somewhere in this rationale for the recommendation section.
Can you send me language?
Yes, I will.
Thank you. I
That's
feel
it.
like I really need that kind of support at this point. I hear you guys, but being able to digest this and
Yeah,
insert it is just
yeah,
a lot right
Got it.
now.
Yeah,
Totally understand that, Brooke. And PS, I want to make the same comment that Janet did. I thought you did an excellent job overall, updating the report to, based on the comments from last time. And I think it's like 95% done.
Yeah.
So please don't take my comments or even my criticisms as, you know, you did a bad job or this report isn't ready for prime time. I think you did a good job. And I think this is ready for prime time. So, you know, these are some last minute policy debates we're having, and I think this is the right forum to have them in. So I wanted to raise those items.
I appreciate you saying that. No, I'm not taking any offense. This has been a really, really tough process. And it still is coming down the
Yeah.
home stretch. So,
yeah,
so thank you.
under a compressed time frame, Brooke. So, anything else on appeals? We are right on schedule here. I will seek you out, Brooke, with some offline comments. It looks like Annette has something, and maybe that was Thomas.
Yes,
Okay, so Annette, go ahead.
I will just offer my perspective on this, that I appreciate the issues you're grappling with, but also note that this is going to the legislature, and I don't know how much experience you have with watching what goes on there. So
Yep.
I wouldn't fret the details too much or try and make it too much more detailed. I think you've got a pretty good product, and I applaud you for doing it. But at this point, you have, I mean, the big issue is going to be money, and where's the money going to come from? And anything that has a price tag associated with it is likely to just be a non-starter. So those are my comments today. Thank you.
Thank you, Annette. Thomas.
well, thank you. I've got a few comments. A part of it is getting the history right. There were several comments in the report that do not correspond to the history as I've researched it. Sometimes they'll compress 2 or 3 bills and something's happening over a few years. And what I'd like to do is not go over them now. I know we're running out of time, have run out of time, but to send them to Brooke, just as these are things that I don't think are quite right. There are 2 other issues. One is the table on page 6 in the executive summary has 10 recommendations under the one that between pages 4 and 5, I think it is. Yeah, between pages 4 and 5 for recommendation 6. Has 10 items. The text later on pages 36 and 37 only explains 9 of them. And the one that's omitted is clarifying the board's supervisory relationship with district coordinators and commissions. At pages 36 and 37 expand on each of the other 9 in that recommendation number 6. And then on page 36, clarifying the board's role in the permit appeals, it talks about, it calls the 2 parties in the dispute, the permittee and the project opponent. And I hope that it is not the board's idea that all non-permittees are project opponents. The report on page 47 talks about Annette's comment about citizens wanting to improve a project. So I suggest softening the language there so it's not permittees and opponents, but permittees and non-permittee parties or something like that, something that's more neutral. And I'll send all of these comments to Brooke, maybe later today, but if not later today, first thing in the morning.
Thank you, Thomas.
With copies to all of you.
Thank you, Thomas.
You're welcome.
Yeah, and Thomas, about the Water Resources Board and the E-Board, I kind of skipped over that because, I mean, the E-Board used to be 9 members, and there was so much history. It was like, I kind of fast forwarded past that nuance. So.
Yeah,
Go.
and yeah.
So I'll put it in
Sarah?
writing, I'll suggest some language, and if you want to fast forward over it again, that's your decision.
Yeah.
Nope, I just hadn't
But I think
finished
the board ought
going
to
through
get
all
it
of
right.
yours. Thank you
Sarah.
for all of your help. I really do appreciate it.
Just before we go into item G, as Pete has rejoined us, I would just wanted to see if we needed to circle back to item D under operations, budget and legislative updates, if there's anything there while we are in open session. Thanks.
We discussed the meeting on November 21st that we have scheduled. There really wasn't much more under operations, budget, and legislative updates to discuss. So unless you have something pressing that I don't know about, I'd like to keep moving. Okay.
No, that sounds good. Thanks for the opportunity, though.
Okay. Let's move on to discussion of attorney-client communications. Sarah, you have a motion for us?
Yep. I would like to move that the board needs to discuss pending and probable Act 250 appeals and enforcement actions, personnel and staffing matters, and to have confidential attorney-client communication on these matters. I move that we find that premature public knowledge of these matters would place the board at substantial disadvantage and the board enter executive session.
Thank you. Kirsten?
I'll second.
Thank you. Any discussion? Okay, all those in favor, please say aye. Aye.
Aye.
Aye.
Brooke, I didn't hear your vote.
Aye, sorry.
Thank you. That is
Frog in
all
my
5
throat.
of us. So we will go into executive session and return back to this session when we are done with executive session. So see you soon and see some of you in the other meeting space.
I'm on my way out of the room.
Say it.
And I'm on my way out of the room.
Gotcha, then I'll stay put.
So you can stay, but,
I appreciate that.
is tomorrow a state holiday?
It is,
So offices will not be open. Thank you.
correct.
Thank you for commenting on my compelling argument.
You're welcome. I agree with you.
I don't always get such direct feedback, other than checking the report and noticing, oh, there or it's not there. Anyway, you've got a executive session. Goodbye.
Bye, Thomas.
Alex, did you have dental work? Are we still being recorded?
We are recording.
Retracts the question.
Okay, we are 4 of us back. Brooke had to depart, so 4 of us are back from executive session. We have no items to report. Last agenda item is to adjourn. Kirsten,
Happy to make a motion to adjourn.
thank you.
I'll second.
Thank you, Sarah. All those in favor, please say aye. Aye.
Bye.
Aye.
Note that 4 board members voted in the affirmative and 1 is absent. Brooke Dingledine is absent. We are adjourned. Thank you, everybody.
Thanks.
Thanks for doing the tech, Alex. Appreciate it.
You're welcome, Pete.
Have a good night.
You too. Have a good holiday.